Just listen to those three calls. We just went through these yesterday. The phone call.
Sir, you got your law degree where? Where'd you get your law degree? Because you got one of the best attorneys in the county standing there next to you arguing this case, and you want to argue it yourself.
I'm just saying we have it.
Well, if you want to argue it yourself, then I'll not pay attention to what Ms. Gaines said, and then what I can do is I can grant their motion and we can proceed right now. Court does call the case. People's State of Michigan versus Sean Caldwell. Counsel, state your appearances, please.
Thank you for the record, Jonathan, on behalf of the people. Good afternoon.
Good afternoon, Your Honor. Joy Gaines, Senior Assistant Public Defender, working on behalf of Mr. Caldwell. Sir, would you please state your name?
Sean Rudolph Caldwell.
Right away, this hearing takes an interesting turn. The judge isn't rushing into a decision. He's making sure every legal argument is heard first. That might not sound dramatic, but in court, procedure often decides the outcome just as much as the evidence itself. Do you think the judge is setting the stage for something much bigger?
All right. Date and time set for prelim. There is a motion. I guess you have defendant's response to the motion that I have in front of me, but there's a motion to proceed by forfeiture or pursuant to 804B6. Any additional argument on that motion?
First, do want to continue my argument that because of the warrant, the people must show by a preponderance of the evidence that Mrs. Caldwell is not present due to anything that has to do with my client, and that they have not met that burden. Your Honor, I would also ask that the court consider a few things. The first is the calls in their totality. I am able to play those, but I also have more context than what was in the motions.
Okay, so that's, I guess, what I want to stop right there for a second. So what you're telling me, for this court to be able to make sense of the August 15th call, there's calls between August 9th and the 15th.
I believe that we have two calls from the 15th, and I believe that there's actually multiple calls on August 15th.
Stop you there for a moment. Do the people know anything about that?
I know that I think there are a total of 4 calls.
On August 15th. So, folks, they don't have them?
I have them, but I don't. The way the calls are listed for me is they are not identified by date, by time, or anything like that. So I have a bunch of calls, but I cannot tell which are from August 15th, which are from September 3rd, or any of that, because they're just listed. Mr. Emmons did give me the calls that they referenced, but in terms of being able to identify those calls, but all the rest are
okay.
Now this is a major problem. Imagine being handed dozens or even hundreds of phone recordings with no dates or order. Without context, even perfectly legal evidence can become incredibly difficult to evaluate. This isn't just about paperwork, it's about whether both sides can fairly argue the facts.
Now you're telling me something else that I'm a little bit worried about. You're given calls. Okay. But you're not told the date of those calls or the time?
That is correct.
Okay, why is that? Or do you know?
I can only speculate as to what I do know. And so I want to be absolutely clear about that.
Okay.
The files that she's given, so when we go to download the files, there is a random, I think this game would agree, 26, 27 character name assignment that has really no minor I understand what it is. So when you download that file, it's just given this kind of 10.26.1 point ampersand, and it goes on and on and on, right? That's the way that the calls are logged within the secure system. And so when there's a massive amount of calls, I believe they're given the files.
Okay.
After the last hearing, Chinaza did approach me and asked me for the hearings. I think I sent them to Chinaza, Miss Akiri Akamuli. I sent them to her as well as Miss Gaines for the 3 calls that were referenced in the report. So I didn't know that they wanted the other 2 or that they needed the other 2 or not. I can certainly provide those. When I downloaded them, I can reassign the file name, and that's what I did when I emailed the reports. These 3 calls that are referenced here, I renamed them to a more understandable system so that they knew specifically what date and time the calls had occurred.
Okay. Fine. But as we stand here right now, Ms. Gaines is telling me that based upon what she received, she can't place those phone calls in order because they update in time.
That is correct.
I don't dispute that. And I mean, I don't know how else to explain it.
No, I see what you're saying. There are other calls out there. You have them. You just don't know when they occurred.
That is correct, Your Honor.
So the only way that you could make sure, I mean, you'd have to listen to all the calls and then try to piece something together rather than being given a date and time of the call.
That is correct, Your Honor. I would have to piece them together based on trying to figure out the flow of the conversation.
So why don't these calls come over? I guess I'm just trying to figure out why. I've never run into this where I don't have, sir, please. Where they don't have the date and time. All right, so where's that date and time come from that you were able to rename, Mr. Emmons?
Yep. So I can access the Securus system. I can download those calls. If I hit the little download button, I can hit that, and then on my computer, it'll bring up a prompt, right? And the default name is that super long, nonsensical tag.
Right.
Right. So then I just go through, highlight, delete that, and I just
But-
put my own.
Okay. But I guess why is defense getting those super long names?
I mean, that I can't speak to. And I only say that I was not the APA that filed this motion. I wasn't sure under what, I didn't learn from Ms. Gaines until we actually started arguing the motion that she didn't have that information.
So am I to understand that when phone calls are given over, there is no sequence to them that one could figure out by what's given?
Your Honor, I can say that this is the 3rd case that I have received phone calls like this.
And I can say that's not my general course of practice. When I've done these types of motions, I provide the relevant phone calls and I try to rename them with the corresponding dates and times. But I understand, given the volume, perhaps why that.
No, I get why it may happen. Okay, I mean, I can grasp that. What I have a problem with in this case is, well, in this
Notice what the judge is emphasizing here. Context matters. A single sentence can sound suspicious by itself, but the conversation before and after it can completely change its meaning. That's one of the reasons courts insist on reviewing evidence in its full sequence instead of isolated clips. Would you trust evidence if you couldn't tell when it happened?
Yes, and there may be others that I have the same problem. I've got counsel I've got people who have filed a motion for forfeiture by wrongdoing. That has to be established in some way. Ms. Gaines is disputing probably not the words of any particular conversation, but what I'm to do with that. But the only way that I can do anything with that, or that Ms. Gaines can make her absolute argument, is if she's able to place those in order so that whatever's being said in this conversation has its context to the best she can figure it out, or at least be able to argue. Am I close?
That's correct. If I may add, although more than one attorney from their office has provided me calls this way, none of them have been Mr. Evans.
Given their motion, I don't know that I'm in a position to deny their motion, but I'm also not in a position to grant their motion. I'm kind of caught in this netherworld because I don't know total. How many calls are we talking?
I think it's about 100. For a determined period of time, from when he was arrested on August 5th to I think September, when the motion was filed.
And I think that's probably correct. I would add that I received a triplicate, and therefore it was what I have is not merely 100 links. I have more like 300 links.
Regardless of what link you're opening, you don't know what date and time we're talking about in the call. So
because as I said,
can I ask?
And may I also just say that I didn't just receive the calls, I also received the commissary orders. I received the checking of the PIN numbers in terms of how much money is in there. So I'm literally going through each of these saying, oh, okay, so that's about PIN. Okay, that's about commissary.
Okay, I get it. So, Mr. Evans, a spreadsheet that's generated. Is there a reason why, and there may be one, I don't know, but is there a reason why defense counsel can't get the spreadsheet?
The bigger problem, for what it might be worth, is that it won't show that file number, the file name. It won't show that on the spreadsheet. That's not.
So just so that I'm clear, if you were to send a spreadsheet over and Ms. Gaines has 100 links and you send a spreadsheet over with that, she couldn't tell from looking at that spreadsheet what link occurred what day.
Yeah, not necessarily.
Oh, so really?
Here's the turning point. Instead of immediately ruling for either side, the judge pauses everything to make sure the defense has a genuine opportunity to review the evidence. That's a reminder that courtroom fairness isn't about speed, it's about making informed decisions based on complete information.
It is making less sense to me the more I think about it. Because if you sent the spreadsheet over and so there's 100 things on the spreadsheet, and she gets 100 links, she can't connect up those links to that spreadsheet.
Right. Yep.
Okay. I don't use this very often, but that's a stupid system.
If I'm able to, reduce it down to her number. I mean, it would be, that means weed out the commissary phone calls, weed out when he's calling inmate information services, that'll take it down a little bit. We're probably talking about, at that point in time, maybe 60, 70.
Okay, so let's say there's 60 to 70. I mean, I think Ms. Gaines makes a good point.
Sure.
Up to the time that basically she would have been subpoenaed to appear. So those 60, how long did that take you to do?
Court gives me to the end of the week. I mean, I can really bust and try to get it done.
Okay. And then once that happens, then you, Ms. Gaines, have to listen to them, right? Formulate. Okay. All right.
Yeah, again, I would argue that, this is information that we should have been provided from the beginning. And that.
Well, I agree with you, except nobody up until today let me know that this was the process, that this was the stop, right?
I apologize. I didn't realize that my argument last time was unclear, because this is what I was arguing.
Well, you were arguing the context of it.
I could not tell the context.
Right, but no, I understood the notion of the context of the call. What I didn't understand is you can't place the context because you don't know when these calls. I mean, I had no idea that you get 100 calls. You had no idea what order they're in. They're just coming at you. Here's what I'm going to do. This is because this is the only way I can. Today's what, the 23rd? You need to get those done, and I'm not saying by the end of the week. I'm saying by the 26th, so that they're in Miss Gaines' hands. The 26th is about 3 days from now. By the end of the close of business Thursday, they need to be in Miss Gaines' hands.
The atmosphere changes instantly. What started as a discussion about evidence is now becoming a lesson in courtroom decorum. Judges expect attorneys to speak for their clients, and repeated interruptions can quickly shift the focus away from the legal issues and onto courtroom conduct itself. Have you ever seen a hearing change direction this fast?
Miss Gaines is then going to have, and I'm just splitting the time frame in half. That's all I'm doing, folks. There's no magic to this. Then that way Miss Gaines will have the 27th, 28th, 29th, and 30th. And at some point, she has to kind of communicate with Mr. Caldwell about what she sees, so that, because he's going to, and I don't know this for sure, but he's also going to be giving context to what these calls mean with her. But she doesn't even have the order. And then I'll hear the motion and do the exam on the 31st. That's the best that I'm going to be able to do, folks, because I don't have the information here.
Just listen to those 3 calls. We just went through these yesterday. The phone call.
Sir, you got your law degree where? Where'd you get your law degree? Because you got one of the best attorneys in the county standing there next to you arguing this case, and you want to argue it yourself.
I'm just saying we have it.
Well, if you want to argue it yourself, then I'll not pay attention to what Ms. Gaines said, and then what I can do is I can grant their motion and we can proceed right now. Is that what you want to do?
I mean, that's about the most unfair thing that.
That would be unfair, which is why I'm not doing it.
Why are you threatening me with an unfair?
Because I don't know why you're talking to me.
This is most absurd.
Okay, all right. You're going to come this close to contempt. So I'm going.
This case leaves us with 2 important takeaways. First, evidence must be organized well enough for both sides to evaluate it fairly. Second, respect for courtroom procedure is essential, because once order breaks down, the consequences can be immediate. Which moment surprised you the most, the evidence dispute or the contempt ruling? Let us know in the comments.
I'm going to tell you just to be quiet. I'm
So
30 days. 30 days. He's got 30 days contempt. I told him to be quiet. He can keep talking if he wants. You want to keep talking? You want to keep talking?
You want to answer your question? You're asking me questions.
Mr. Collins, please.
Why don't you want to answer?
He's got 30 days contempt. Take him out. I've given you the schedule. That's what we'll do. This is adjourned to the 31st.
I don't mean to bemoan the point.
But you're about to.
I'm about to. You've given him the 30. Are we in a rush to have it on the 30?
I'm in a rush to have it unless you guys can agree, because I'm sure Miss Gaines is going to try to get me to set aside that 30 days contempt.
I imagine you would.
This ending is a textbook example of how quickly courtroom decorum can change the outcome of a hearing. The defendant repeatedly interrupted, despite having experienced legal counsel arguing on his behalf, and the judge responded by holding him in direct criminal contempt, an authority courts use to preserve order and respect for judicial proceedings. Importantly, the contempt finding was separate from the underlying criminal charges. It was based solely on the defendant's conduct in court. At the same time, the judge still preserved the defense's opportunity to challenge the prosecution's motion once the evidence is properly organized, showing that courtroom discipline and procedural fairness can exist side by side. Cases like this remind us that how someone behaves in court can be almost as important as the legal arguments themselves. If you found this courtroom showdown fascinating, be sure to like the video, share your thoughts in the comments, and subscribe for more real courtroom breakdowns where we explain not just what happened, but why it matters.